Welcome to our channel. Today we're diving into the world of California eviction laws. Whether you're a landlord or a tenant, understanding these laws is crucial for a smooth and fair housing experience. California is known for its strong tenant protections, but what does that really mean in practice? Let's break it down. First things first, what are the valid reasons for eviction in California? Non-payment of rent is the most common reason, but even then, there are strict rules landlords must follow, like the 3-day notice rule. Lease violations are another big one. This could include things like unauthorized pets, subletting without permission, having an extra roommate not on the lease, or noise complaints. Illegal activity on the property is grounds for immediate eviction. It's important to remember that California law requires just cause for eviction. This means landlords can't just kick someone out because they don't like them. Now let's say a landlord has a legitimate reason to evict someone. What happens next? It starts with a formal notice. This notice has to be very specific, stating the reason for eviction, deadlines, and even where to pay rent. It also has to be delivered properly, meaning hand-delivered, left with someone, or mailed in a specific way. If the tenant doesn't respond to the notice, the landlord can file a lawsuit called an unlawful detainer lawsuit. This is the legal way for a landlord to get their property back through the courts. Tenants can fight back against eviction, even if they did something wrong. They can respond to the lawsuit, present their own evidence, and even bring up defenses. One interesting thing about California law is the concept of affirmative defenses. This means a tenant can argue that even though they might have technically violated the lease, the landlord did something that justifies their actions. For example, a tenant who repeatedly asked for repairs that the landlord ignored might use those ignored requests as a defense against eviction. Another affirmative defense is retaliation. If a tenant complains to the city about unsafe conditions and the landlord tries to evict them, the court would likely see that as retaliation and wouldn't allow it. The Tenant Protection Act of 2019 brought in a lot of new protections for tenants. It limits how much rent can be raised each year. It makes it tougher to evict someone without a good reason. The law also protects tenants from being evicted just so the landlord can raise the rent or let a friend move in. What happens after an eviction? Even after a tenant moves out, there are still legal things to consider. Landlords have to follow specific rules about handling abandoned property. They can't just throw it away or keep it. Security deposits can only be used for certain things like unpaid rent, cleaning costs, or damage to the property. So what's the bottom line? California tenant law is complex, but it's designed to be fair. It's about balancing the rights of landlords and tenants. Knowing your rights is crucial, whether you're a landlord or a tenant. Do your research and understand the specific laws in your area. Thanks for watching. We hope this video gave you a better understanding of California eviction laws. Remember, knowledge is power. Note, it's always best to consult with a legal professional for specific legal advice. Remember to like, share, and subscribe for more insights.
Call now 714-442-9741. Thank you.